Hello, everyone. Welcome to our latest ALTA Insights webinar. I'm Jeremy Yohe, ALTA's Vice President of Communications, and today we're going to provide some analysis of FinCEN's anti-money laundering rule and dig into how it will impact your operations. With about 750 registered for today's presentation, definitely a lot of interest in what will probably be the most significant regulatory change impacting the title industry since TRID. I've got a few housekeeping items to go over before starting. Today's webinar is being recorded. You'll get an email with a link to the recording tomorrow, and you can always access all of our webinar recordings at alta.org/webinars. You can download a PDF of today's presentation from the handout section in the GoToWebinar window pane. You'll also get an email tomorrow with a link to download the presentation and access the recording. If at any time you have a question or comment, submit them in the questions box. We'll hold some time at the end for Q&A. I do need to thank Closing Lock for sponsoring today's webinar. And before introducing today's speakers, we have a short message from Closing Lock.
Title companies have a really hard job right now. Not only do they have to process all these transactions and deal with demanding customers, but they're dealing with the growing risk of fraud. And one specific problem in the industry is a lot of the legacy insurance policies out there don't have specific applications for wire fraud. And that leads to title companies or their clients being liable and out funds when something happens. So we're really excited to roll out Closing Lock Insurance, which is a brand new purpose-built insurance policy to protect funds on a real estate transaction. This is included for all of our customers at no additional charge and is built right into the Closing Lock platform. So it's very clear when you do a transaction, what exactly is covered or what steps you need to take to make sure that you have coverage on your transaction. The insurance is the largest in the industry. It's up to $2.5 million per transaction. And we're really excited to roll this out. And we're going to continue to focus on building one comprehensive platform that's going to protect and insure title companies and their customers.
All right, thank you, Closing Lock, for that message. I can do a few things here on my screen, and we will introduce the speakers. Okay, all right, thank you, Closing Lock. Joining us today, we have Melissa Murphy. Melissa is General Counsel for Attorneys Title Fund Services, better known as the Fund. She serves on a host of ALTA committees, including Government Affairs and the State Legislative and Regulatory Action Committees, as well as best practices, data privacy, and digital closing work groups. Specific to this discussion, Melissa has practiced law for over 30 years, dealing with real estate transactions every day. Melissa, sounds like you stay pretty busy. Also joining us, we have Thomas Luzier. Tom is partner of Williams Parker Attorneys at Law, which is based in Sarasota, Florida. Tom is board certified as a specialist in real estate and leads the firm's real estate practice. Tom, thank you for joining us as well. Both Tom and Melissa gave a similar presentation at ALTA 1 earlier this year in October, and we just wanted to bring this conversation to a larger group and continue this education. Helping us today, we also have Steve Gottheim. Steve is ALTA's General Counsel and has more than 15 years of experience in financial services. During this time, Steve has spearheaded many legislative and regulatory issues, such as implementation of Dodd-Frank rules, TRID, and FinCEN's geographic targeting orders. With that, Melissa, I'll turn the conversation over to you.
All right, thank you very much, and thanks everybody for joining us today. Jeremy, if you'll advance to the agenda.
Yep, we're there. You should be. If not, no.
I do not see it.
You know, it helps.
There it is. There it is. Okay.
It helps if you share the presentation after showing the video. So sorry about that.
All right, guys. So we're going to talk about the basics about this new rule, but we're going to start off talking about the why behind FinCEN's desire to gather this information. Then we're going to talk about the rule itself, and interspersed throughout the presentation, we're going to point out areas where it might impact your business and ways in which you can begin to think about preparing. So our approach is to review the provisions of the rule at a high level and then begin to do a little bit of a deeper dive into each of the areas. But here's our caveat, one of many probably. We will not be training you on how to comply with rules. So don't expect to leave the webinar today ready to file your reports. This is a very high level review of what the rule requires, what it covers, why FinCEN wanted to do this rule, and then again, start exploring ways that you can begin to prepare. Next slide. I love this slide. It's Steve's slide, but the lawyers made us add this to just clarify that we are not giving you legal advice on what transaction you might be handling, whether or not the rule applies, etc. You need to consult with your own legal counsel about that. With that little bit of introduction, I'm going to turn it over to Tom to talk a little bit about the background behind FinCEN and why they are involved in anti-money laundering.
Thank you, Melissa. Great to be here today. So to understand FinCEN, you have to think in the broader context of the Bank Secrecy Act, which was enacted many, many years ago, and is a mechanism for collection of information about transactions that fit the bill for potentially suspicious, whether it's currency transactions or deposit transactions, and that exists under the purview of the Department of the Treasury. Fast forward from that, which I believe was 1970, there was never direct agency oversight, if you will. There was no one at that level, at the federal level, that was charged with looking at this information and aggregating it in a manner that took account for national security and law enforcement activities. And so in 1990, FinCEN, the Financial Crimes Reporting Network, enforcement network was established, and it effectively became the collector of information that was being developed through banks, mortgage companies, financial institutions that have anti-money laundering, AML, reporting responsibilities. And their charge at FinCEN is to collect this information and to analyze it in the context of ongoing law enforcement initiatives across the range of constituents, both domestic and international, for whom this information would be relevant in their activities trying to combat money laundering. And so they're taking in information about potentially suspicious activities and analyzing that, sharing that with groups like Homeland Security, the IRS, SEC, ICE, also international governments, and anti-terrorism activities. And so in one sense, they are an aggregator, but they are more than that. They actively analyze and disseminate this information. So all of these law enforcement agencies or agencies with law enforcement actions within their purview are playing from the same, singing from the same hymn.
Next slide, Jeremy. A real quick word about real estate professionals and the Bank Secrecy Act. Originally, you all were included in the BSA definition of a financial institution, which would have triggered a requirement that you have an anti-money laundering program at your title agency. And back in 2003, our industry was given a temporary exemption from the requirement of having a full AML program, the thought being that this was duplicative of what mortgage bankers were reporting. I point this out because FinCEN makes a point of that in the opening remarks to this final rule. They point out basically we're going easy on you guys because we can revoke this exemption at any time. And we're not requiring that you do a full AML report or a suspicious activity report. What you're required to report on this rule is like a suspicious activity report light. So I'm just pointing that out so that you have the full context of why we are where we are. Next, I want to talk a little bit about money laundering. I'm not going to talk about placement and layering, but I'm going to talk about this last phase of money laundering. But basically the way it works is the bad people take money that they have earned from ill-gotten gains, illegal activities, however nefarious they might be, and they spread that money throughout the banking system in many, many, many deposits in order to make it difficult to trace that money. But then what they do is they aggregate that money and they want to invest it in a legitimate business. And this new FinCEN rule is focused on this last stage, integration, helping FinCEN understand where this money is being placed, how it is being used, not about the first couple of phases, but about that ultimate last phase of integration. And now Tom is going to talk a little bit about why real estate is of interest to FinCEN.
And Melissa, as you said, part of the process of laundering the money is in recognizing that financial institutions have reporting requirements for suspicious activity, deposit activity, cash transactions, and so forth. Anyone who is worth their salt, who's doing this, is aware of what those requirements are and of the need to potentially piecemeal the deposits and so forth. And so when you're looking around for where is a place that I can put my money, that I can do so efficiently, perhaps in one transaction, they're not going to ask a lot of questions, and it's not going to trigger any alarm bells, any reporting requirements. That sounds a lot like a residential real estate transaction. In fact, by some estimates, as you look at the slide, between in the 5 years between 2015 and 2020, more than $2 billion worth of residential real estate was involved in such placement. And so FinCEN, realizing that it has this group of professionals who are a wealth of knowledge about these transactions, i.e. closing agents and attorneys, they realized we can probably collect some information that's relevant to our efforts to combat money laundering. And so if you go to the next slide, back in 2016, they came up with the first of their geographic targeting orders, also known as a GTO. Some of you may be subject to that. We are in my jurisdiction. And initially they covered just two marketplaces, New York City and Miami, both known for lots of cash, lots of international investment and so forth, focusing on entity purchases of residential real estate. GTOs always have an expiration date, and as they would expire, they were expanded in scope and they were expanded in time. And so renewed, expanded, here we are. Currently, the GTOs cover 69 counties in 13 states, plus the District of Columbia. The cash transactions are those to entities for 300,000 or more. FinCEN realized over time, as it was doing its job analyzing the data, that nearly 40% of the reports that they received up from the closing agents, they could correlate to suspicious banking activity reports they were receiving from financial institutions. About 7% of those could be tagged to an ongoing FBI investigation. So success begets success. The GTOs beget the rule. And Melissa, tell us what we're in for.
So finally, we're getting to the rule itself after that background and setting the context for you. And again, our approach today is to hit the high points and then backtrack and go into more detail. So what are the basics? Effective date, December 1st, 2025. Now, don't leave the webinar because don't feel like that gives you a free pass for the next 10 or 11 months. This is not a rule that you can learn about and get your compliance process in place in 2 weeks or 30 days. But FinCEN did give the industry plenty of time to get ready. So December 1st is the magic date. What transfers need to be reported? All non-financed cash transfers of residential real estate where the transferee is an entity or a trust, not a transfer or sale to an individual, an entity or a trust. Now, there are several categories of exempt transactions, and we will cover those. Who must report? Well, this is pretty simple. It's you. I mean, there is a cascade of different levels of responsibility for who must report, and we will go over those. But you should think in terms of you are going to have to do the reporting for these transactions. Next, we're going to talk about what must be reported. Basic transactional information, that's pretty easy. Closing date, purchase price, the parties' names. You have to report information about the transferor or the seller, and that includes beneficial ownership of the transferor if applicable. Transferee information, including beneficial ownership information about that transferee, and that's where this thing gets a little sticky. You also have to report information about how the purchase price was paid. Where did that money come from, and details around that. What's your deadline for reporting the transaction to FinCEN? Well, there are two options there. It's either it is the later of, the last day of the month following closing, or 30 calendar days from closing. So it does give you the choice of how you want to approach your reporting procedures, your reporting processes, but that's your deadline. And how do you report? Your only option is electronically through a website that FinCEN has. And the document that must be completed and filed is called the real estate report, nothing fancy there. FinCEN will issue the form that has to be used. They have issued some preliminary outlines of what information has to be put in that report, but they will issue the final form that you have to use. All right, Tom, you're going to go into a little bit of detail about the kind of property that is covered by the rule.
That's right. Any good rule has got definitions, and this one definitely has that. They define residential real estate as you see on the slide, and it's very broad. Basically, it's real property that contains a structure designed for 1 to 4 family occupancy. That can be a home, that can be a condo, it can be a co-op, it can be a mixed-use property. Interestingly, they also define as residential real estate vacant land on which a transferee intends to build such a house. Now the question you may ask yourself, well, how on earth am I going to know that the transferee is going to build a house on the property? Well, you're going to ask, and we're going to talk a little bit more about that. This includes sales throughout the contiguous United States and extraneous, any overseas, Indian lands, territories, you name it. It covers a broad swath. It also goes on to provide a definition of, rather than a cash transaction, they're calling it a non-financed transaction. So if I can have the next slide. So what constitutes a non-financed transfer? So as Melissa said earlier, they're trying not to duplicate the information that's being received up from banks, mortgage companies, and so forth. And so it's any transaction that doesn't have this type of reportable financing involved. Now, you may say, what about where there's seller financing? Is it exempt? What if there's a hard money lender involved? Are they exempt? Answer is they likely are not. And how are you going to determine that? You're going to ask whether they have anti-money laundering reporting requirements, and NMLS number, etc. Melissa?
Let's talk about what entities are covered. So if the buyer or the transferee is a legal entity, which basically means any kind of legal entity, LLC, corporation, partnership, limited partnership, it is an entity. A transferee trust is also covered by the rule, and they define that as any arrangement where assets are placed in the title of a person for the benefit of one or more other persons, generally, your typical understanding of a trust. And I want to point out that reporting still applies even if a co-purchaser is not someone that must report. So if in your particular transaction, an individual buys 50% of a residential property and a corporation or an LLC buys the other 50%, that is a reportable transaction. It's not exempt because an individual bought a percentage of ownership. Now, there are limited exceptions for certain types of entities. Those exceptions are similar to the Corporate Transparency Act exceptions, which I think maybe everybody now knows that enforcement of that or compliance with that is now on hold based on a very recent Texas case. But nevertheless, there are limited exceptions for certain entities, and the rule actually sets out a list of those entities that are exempt from the rule. So that's one way that you will know if an exception applies to your particular buyer or transferee, is whether or not they clearly fall under one of the categories that is listed in the rule as being exempt from the reporting. But again, as Tom already alluded to several times, you're going to ask and you're going to get the buyer to tell you whether or not they are exempt. So let's talk next about which transactions themselves are exempt. For that, I'm going to go back to Tom.
Right, Melissa, and just like there are certain entity exemptions, thankfully, there's certain transactional exemptions, and any closing agent worth their salt, the first thing they're going to ask is, how do I get out from under this requirement? And there are opportunities. And so as you look at this slide, you'll see that some of the language is plain text, some is italicized. When the rule was first published and put out for public comment, there were hundreds of individuals and organizations that weighed in on the content of the proposed rule and what it should look like when adopted. And so the language that's italicized in this slide is a result of public comment that occurred and are additions, amplifications, clarifications to these exemptions, and quite helpful as a result. Some of these are kind of no-brainers. Transfers incident to a divorce, a bankruptcy, an easement transaction, those make absolute sense. You'd probably have to be the most diabolical money launderer to figure out how to put your money through one of those and hide it. Some more power to you. Where there's no reporting person involved, and we'll get into that a little bit later. Then you see things like transfers resulting from the death of an individual, whether by the will, the trust, and so forth. And so if your practice involves trust and estate settlement, or you're adjacent to that, that can be quite helpful because those can be a frequent source of transfer activity and otherwise would be reportable but for the exemption. If you're in a jurisdiction where there's been a lot of appreciation, you probably have seen an upswing in 1031 exchange activity. They added in an exemption for transfers to qualified intermediaries in connection with these exchanges. Helpful, probably a little esoteric, but helpful nonetheless. There are a couple that bear a little bit more discussion, and we'll talk about that on the next slide. Transfers involving a trust from individuals to their trusts. Again, that's That's a active tool in the estate planning world where we are, and probably throughout the country from what we know. And so that is quite helpful to have. Likewise, corrective deeds are not technically considered transfers, therefore they're not reportable. Transfers supervised by a court, quote unquote, are also exempted. So the question then becomes, what does that mean? And how is that applicable? And so an immediate reaction in Melissa's and my jurisdiction in Florida, you think, what about a foreclosure? We don't have non-judicial foreclosure options in our state. So those processes are a creature of the court from beginning to end. And then once the judgment's entered, of course, the clerk takes over and advertises the sale, issues the certificate. You may be issuing title insurance in connection with that, but for all intents and purposes, we're pretty satisfied that's not a reportable transaction. The point of this is going to be on a case-by-case basis, depending on the facts of what's happening, what's applicable in your jurisdiction, and you're going to have to make the decision for yourselves whether or not you think it's reportable. Unfortunately, with the new rule, there are not immediately FAQs or a roadmap, although those are in development. Melissa, I think you're probably going to talk a little bit more about that, or we'll mention that. So there will be some guidelines developed over time that will help shed some light, but initially it's going to be up to your judgment and your due diligence to figure out whether the exemption fits. Melissa?
Thanks, Tom. Now I think we're going to turn it over to Steve. Steve, it's your turn to lay on some knowledge.
Yeah, so thank you. And thank you to Melissa and Tom for really starting to lay out just the very basics and kind of helping people understand what are the types of transactions that are going to be covered here. I think one of the first steps that any agent should take, especially after doing a webinar like this, is to think back and look through your book of business from 2023, or to the degree you can look back through enough of 2024 to get a trend, and really get a better sense of how many transactions did you close this year where the buyer was an LLC, where the buyer was a trust, how many of them were for all cash. I think as you start to understand what your potential volume of reports looks like, you'll start to realize that as we go through the rest of this webinar, there's a lot of decisioning that you'll get through that is going to be dependent on whether or not you're going to be a high volume filer or a low volume filer. Some things will never make sense if you're a high volume filer versus some things will never make sense if you are only going to do 5 or 6 of these a month or a year. As part of our understanding of trying to get a better sense of how big a burden was this entire rule going to be on the industry, we worked very closely with the folks at First American, and you can see their slide and data here on the slide here. And I want to thank Mark Fleming, Odetta Cushy, and Sam Williamson for their help in pulling this data together. They looked at their national data around from their tax assessing database to try to understand just how many transactions happened in the last few years that would fit the basic criteria of this rule. And what you get is, on average, it's between 8 and 12% of residential real estate sales might fit the criteria at the high end. This means if you look at just the 2023 data line here, just about 490,000 transactions would have been reportable as at the high end under this rule if it had been in place in 2023. So that gives us a good place of starting point of understanding what's the impact of this rule on the industry, but also a great way for folks to think about the type of analysis you can do yourself. If we go to the next slide, Jeremy. We've also asked, and First American was also able to take a look at this again by city or metropolitan area. I know it's a little bit hard to see this, but you can see some of the metropolitan areas here, especially in the top 50, where we'll have more or less of these potential reports, and things like Phoenix and Miami and Atlanta and New York and Raleigh and Chicago. Obviously, some of the big cities are going to have more volume. What you'll notice here is, a large number of these cities have a higher potential exposure because of the number of trust transactions in those marketplaces. And as we'll get to, many of those trusts may or may not be reportable based on that exemption that Tom talked about earlier. So, we are still going to have to figure out, what the real estimate is. But these are just to give you kind of high end estimates to understand where the marketplace may be. So if we go to the next slide. So I'm going to turn it back over to Melissa now to start talking about, how you're going to figure out, once you've figured out you have a transaction, how you're going to actually start collecting this data.
And for that, I'm going to turn it over to Tom.
Sure. It's all hands on deck. So so as a closing agent, you're sitting here thinking to yourself, I'm responsible on the hook to report to this government agency this information about this transaction. What can I rely on, and how am I on the hook? I'm only as good as the information that I'm provided, and what am I expected to stand behind? I think those are all reasonable questions to ask. And so luckily the rule establishes a reasonable reliance standard in terms of the information that's provided to us and then upward to FinCEN. And so the best way to think about this is there are two levels to it. There's the what of the transaction, and there's the who. The who is the important kernel, because what they're trying to get to is who's behind these transactions that are occurring. The what is kind of the ambient information surrounding that. The flow of the funds, the address of the property, the intent to build something on the property. So for all of that what kind of information, so long as what you're reporting up you don't believe is false, as long as you don't reasonably have, as long as you don't have reason to believe the information that you are providing is not true, then you may reasonably rely on the information you are provided in whatever manner to in turn provide to FinCEN. Distinguish that from beneficial ownership information. That's the important part. So when someone is providing you with written information about who owns the transferee entity, the reporting person is going to be required to say in writing, to the best of their knowledge, that they certify that the information that's being provided is accurate as to that ownership. Notice they're not requiring an affidavit, not requiring it to be notarized. It is a certification to the best of the reporting person's knowledge. And you as a closing agent are permitted to rely on that and pushing that upstream to FinCEN at the closing of your transaction. So Melissa, let's talk a little bit about what is information that's reported.
So next slide, Jeremy. And before I get into this, I think that reasonable reliance standard really was a positive thing for FinCEN to offer to the industry and incorporate into the rule. So I think that's a very positive aspect of why it's so important for organizations like ALTA and state land associations to participate in this process, where we provided feedback to FinCEN, and on that issue they listened to us. Maybe not so much about the information that I'm now going to review with you. So let's do a little bit deeper dive into exactly what information has to be reported. So the what? Transactional information, information about the property, the street address, the legal description, the date of the closing, the purchase price. That's pretty easy. Information about you, the reporting person. What's your legal name? Business name or individual name? What category of reporting person do you fall within? And that's what I mean by the waterfall. And we'll talk more about what exactly we mean about the waterfall in a minute. But what category of reporting person do you fall in? And then what's your address? Information about the seller. If they're an individual, legal name, date of birth, residential address, IRS tax ID number, social security number in most situations. If the seller or transferor is an entity, full legal name, DBA if there is one, business address, tax ID number, or foreign equivalent if they are not a US entity. If the seller is a trust, they want the full name of the trust as listed on the trust agreement. That's specifically in the rule. The date the trust agreement was signed, tax ID number if available, and the legal name, address, and tax ID number for the trustee, whether they are an individual or an entity. So a little bit more information than required under the geographic targeting orders, but pretty much doable for the transferor. All right, let's get into the thick of things with a review of the information that is required from or about the transferee buyer. If they are an entity, legal name, DBA if there is one, current address for principal place of business, tax ID number, or foreign equivalent, or entity registration number, something that is associated with that entity. You have to report the beneficial owners of that entity, and for each beneficial owner, full legal name, date of birth, current residential address, citizenship, unique ID number. And whoever is signing on behalf of that entity, what's the capacity in which they are authorized to act, and if this is part of their job, the name of their employer. So high-level information about the entity. Let's do a little bit deeper dive. Who are the beneficial owners of an entity? Any individual who controls either directly or indirectly 25% of the ownership or exercises substantial control over the entity. All right, what's meant by substantial control? If you're a senior officer, you're a beneficial owner of that entity. If you have the authority to appoint board members or senior officers, you are a beneficial owner of that entity. If you have the ability to direct decision-making on important financial decisions, you are a beneficial owner. And you can see how the definition of substantial control clearly makes this rule applicable to both profit and nonprofit entities, because nonprofits don't have ownership interests, but they do have individuals that exercise substantial control over them. So pretty clear, profit and nonprofit are covered. All right, that was entities. Now let's move to a transferee that is a trust. You need to report the full name of the trust, the date of the instrument, unique ID number, whether that trust is revocable. So you can see where that certification in writing that Tom mentioned that allows you to have that reasonable reliance is important, because you're going to rely on a representative of this trust to tell you that the trust is revocable or not. You need trustee information. If they are an entity, we want their legal name, any DBA, their business address, and their unique ID. Transferee, more transferee information. Who are the beneficial owners of a transferee? The beneficial owner information that is required when I'll get to who the beneficial owners are in a minute, but if they are a beneficial owner, we need their legal name, date of birth, residential address, citizenship, unique ID. And how do they qualify as a beneficial owner? What category do they fall under? I'm going to cover that here shortly. And then someone is signing on behalf of the trust. So for that signer, we need legal name, date of birth, residential address, unique tax ID, and what is the capacity in which they are authorized to act. And again, if it's part of their employment, who is their employer? All right, so that's the information that we need from beneficial owners. Who are beneficial owners of a trust? If the trustee is an individual, that individual is a beneficial owner of the trust, even if they're not a beneficiary of the trust. If they are an individual and they are the trustee, they are considered a beneficial owner of the trust. If there is another individual other than the trustee that has the authority to dispose of trust assets, they are a beneficial owner. A beneficiary that is the sole recipient of the income and principal from the trust, or has the right to say, hey, trustee, give me all of the money, then they are a beneficial owner. The original grantor or settlor of a revocable trust is considered a beneficial owner. And then if an entity holds any of these positions, then you have to drill down into who are the beneficial owners of that entity. Now, before we go to the next slide, pause, take a deep breath, because I think you should realize now that this is a multi-layered rule, that there is a lot of information and a lot of data to collect here. And again, we're just trying to expose you to the scope and depth of this rule. You're going to have to undertake specific additional training once the real estate report is issued by FinCEN, and we're ready to help you comply with the rule. But you can see how complex this can get, particularly when a trust is a beneficial owner. So maybe we're moving to something a little bit simpler, Tom. What about how the money is paid?
An important part of the overall picture, for sure. That was a lot, Melissa, and every time you go through that, I'm always amazed. Obviously, they're tracking the flow of the funds as well. And if you're subject to a geographic targeting order currently, then you're familiar with the currency reports, and what's being required under the rule is not significantly different from what we're already doing in that regard. You're reporting the purchase price paid, but keep in mind that they've drilled a little deeper on that, and they're asking for inclusion of any amount that's paid outside of the closing. And what we think they mean there is, in some cases, you'll see consideration assigned to the real estate, and likewise, there'll be consideration assigned to personal property or other improvements and so forth. And so it's the big picture of what's being paid for the property, which is what is being reported. You're also reporting up the flow of the funds, where it's coming from, who it's coming from, how it's coming to you. And of course, any of that information is readily available or should be within your system, whether it's images of checks, whether it's your wire confirmations on the incoming flow. That information's all available. If not, you're going to ask for it. If there's any private money lending involved, regardless of the source, and if it's not someone that has reporting requirements, you're going to be providing information about that. And again, any information that's not readily available, you're going to ask for and include as part of your report, which leads us then to the question of who is responsible for reporting, who must report. And so as we figured, it's all of us, right? But the rule sets out what it calls a cascade or a waterfall of responsibility. And the top line responsibility rests with the person that is listed as the settlement agent on the transferee's settlement statement. You could be in a situation where someone is preparing a settlement statement or is identified as the agent for the transferor. You're the agent for the transferee. In that case, the responsibility is yours, not theirs, and so forth down the line. When I first looked at this list, I thought to myself, we're everybody on this list, so there's nowhere to run, nowhere to hide. So the next thought was, perhaps someone could make a mint trying to outsource or be an outsource for the reporting obligations. If you go to the next slide, there is such an opportunity to delegate downward within the waterfall to folks that also have the responsibility who may not be you. However, you cannot do so on a blanket basis. It's per transaction. It has to be a written agreement, and it has to satisfy all of the requirements that you see on the screen, including date, addresses, and so forth. In my estimation, you're probably not going to see a lot of use of the designation agreements, but again, this depends a lot on your jurisdiction, how your closings take place, who has what role within the waterfall of responsibility. Melissa, I think you're next. to talk about impacts on the business.
Yeah, and I think Steve has some comments, like an update
Right.
as to how these things are being reported.
Yeah, so as Melissa said, most of this is going to be done in an electronic fashion when you decide to, when you have a transaction that gets reported. You can see here on the screen, for those of you that have done the GTOs, you might be familiar with the BSA e-filing system. For those of you that have not, you'll have to learn this system. You can see a quick screenshot of kind of the data fields that are in this report. I think that the thing that you'll have to think about, and this is back to the earlier comment about understanding what your volume might look like, is there's three options of how you report. There's going to be the ability to hand type over every piece of data from your file into the report and submit it online. There's a way for you to upload a PDF version of one of these reports. And then for those high volume filers, there is a quasi API that people are going to be able to use. And so as you start to think about what your volume looks like, you'll really want to then start to think about each of those comes with different costs and burdens on your staff, and how you're going to do this is going to become really critical to understand your path forward. If you can go to the next slide. There's a lot here in the cost estimate. FinCEN produced a cost estimate. You can see it on the screen. It is very, very high, staggeringly high. It's something that we're very focused on at ALTA about how do we make sure that the cost is hopefully as low as possible to all of you. I will say, a lot of FinCEN's cost estimate is based on that very high estimate of the number of filings that we don't think is realistic. But this is not going to be something where it's just, easy, a couple, an hour or so on every transaction of different time and cost. And so, companies will have to start to really think about, again, how many of these are you going to do? What is the actual time commitment going to be for a staff person? How are you going to collect all of this data? How are you then going to transmit it over to FinCEN? And as you start to understand what that staff cost really looks like, you have to then think about, what are you going to do with, whether it's, increasing your, increasing your closing fees, charging a separate FinCEN fee, charging other, or, eating the cost. There's nothing in this rule that prevents you from passing along the cost to your customers. And so understanding that will, and what your volume looks like, will help you make better decisions as you start planning for what that revenue and expense might look like. If we can move to the next slide.
I think you're going to cover this, Steve?
Yeah. So record
Okay.
keeping is an interesting part of this here. FinCEN will claim that they were doing the industry a favor by cutting back the record keeping requirement to just only having to do some of the data has to be kept for 5 years after the report. The reality is the cost of holding records is pretty cheap, and the reality is nobody wants to be left empty-handed by not having a record when FinCEN comes and does an audit, or when your state insurance commissioner does an audit. So, I don't know how relevant it is to go through, what do you have to keep for 5 years and what don't you, but really anything that you use as a certification or for that reasonable reliance is going to be something you want to keep at least for the 5 years. If we go to the next slide. So, Melissa,
and I think Tom and I are going to kind of throw this back and forth. What are the things that you need to start thinking about? We've mentioned most of these already, and maybe you've reached your own conclusions, and maybe you agree with every bullet point on this list. But I think the threshold question that Steve has really driven home is, how many cash transactions to an entity or a trust do you think you're going to handle? Are you in a market that has a lot of cash transactions? Tom, I think you have some experience with this.
We do, and we went back and took a snapshot over a period in the past year, and it was actually about a quarter of our production. So it was a few hundred transactions, to be honest, and so it can be quite extensive depending on where you're located.
And think about at what point in your workflow are you going to begin collecting information? To me, it's maybe self-evident that you're going to start the minute you get a contract in. You're going to evaluate whether or not you think this has the potential to be covered by the rule. How will you collect information? How does your office handle that under the GTOs, Tom? Because that would be similar.
Yeah, so the GTOs have been a great experience so far, and referring back to the prior slide where the estimated training time, that's probably pretty accurate. All of our paralegals have, whether they are the client facing or in post-closing functions, have all been trained on this. It's probably accurate in terms of the training time that's involved. The paralegals that work with the clients directly, as soon as they see a transaction that's going to fit the bill for reporting, they're going to start collecting the information. Sometimes they change horses in the middle of the transaction or late in the transaction. And of course, we don't have any standing to modify the party's contract, so we're going to move as fast as we can to collect that data and hopefully get the reporting requirements satisfied by the time we close, as opposed to having to wait and chase it afterwards. But again, the forward-facing paralegals are the ones who are collecting the information initially. As soon as they're tipped off that they have something like this involved, they collect it along with everything else that they collect and try to get this resolved.
Well, and I do think that when agents go through the more intensive, specific training, a solution will emerge in their vision as to how their office operates, and that will help them determine who on the staff is going to be responsible for collecting information, for
Sure.
doing the filing, for making sure that after the closing, the file is complete for storage purposes. And the last bullet point here to me is the million-dollar question: how will you determine a fee for complying with this? That's very, very challenging for our industry to figure out. And in some jurisdictions, you may need to get your regulators' permission and approval of that fee, or at least the process for adopting that fee. That's not the case here in Florida, so I'm not as familiar with how involved that might be. Steve, you may have a comment there, but it is going to vary from jurisdiction to jurisdiction as to what control you have over setting a fee for compliance. And then on the next slide, I think this is going to be very, very challenging, Tom. What if you can't get the information? Maybe you face that with the GTO, but what are your thoughts there?
So we have faced that with the GTO. It was actually, it involved a longstanding client, and we sent, and of course ALTA has a form to collect the information that we utilize for the reporting. So we sent that over to them and said, we need this completed. We need to have the beneficial ownership information so we can provide this reporting and so forth. In fact, if you'd like, call us up and we'll help you through it. So we got on the phone, and after a couple of minutes of what's happened to our country, and I can't believe that this is the USA, they took a breath and we said, look, you know from experience, we're never going to do anything to make your life harder, but understand that this is a necessity, it's not a nicety. And if we don't get the information from you, we're going to have no opportunity, we're going to have no option other than to file a suspicious activity report, which means the FinCEN folks are going to be calling you directly. The information flowed, the filing was completed, the accident was averted. But sometimes you may not get the information or be able to. And so so far we haven't had a hard no, and the threat of the suspicious activity report has been sufficient.
Perfect. So next steps, next slide. So what's going on now? And Steve, you can certainly chime in here. FinCEN needs to finalize the real estate report form. Bring us up to date on where we are there.
Yeah, so currently FinCEN has an open comment period on their draft report form. ALTA's FinCEN work group that Melissa is on is going to be drafting some comments and addressing some of the questions that have come up in this presentation in those comments. Along with that, we as a work group, we've got a whole host of projects going on, as you can see on the screen, all designed towards either getting you ready for December 1 with a whole bunch of education and really the in-depth training that Melissa talked about, and a lot more updated resources like Tom talked about to help you collect that information, get those certifications. So, you know, as you go into 2025, really keep a lookout to your Title News Online and your ALTA communications for some of the latest on the materials that we're putting out to help you get there. If we go down to the next slide, we'll kind of end before we, move to questions. Just the one thing I will remind you, and you'll obviously get copies of this slide so you can look at the numbers yourself, but the reminder here is the Bank Secrecy Act, as Tom said, it's not just a nicety, it's a necessity, because it's not just with civil penalties if you don't follow the law here, it's actual criminal penalties. And we'll get into how some of that plays out to some of the questions that have come in so far in the presentation. So as a reminder, again, as you have questions, send them in through the chat box. We've got a good number of them. I don't think we'll get through all of them in the last few minutes that we have together, but we'll try to get through to a couple of them. And apropos of that criminal liability point of view, we had two questions that came in very similarly, one from Andrea, one from Alan, asking, what about when a person decides to buy property individually and then immediately transfer it to their LLC the next day? How does the reporting work there? And I think the short answer of that is, if you as the settlement agent know that that's what they're going to do, you're going to have yourself some potential exposure for helping them design a transaction in a way that is intended to evade this reporting, and again, open yourself up to that criminal sanction, into some of those criminal sanctions. Those are, as you noticed, willful violations, and a willful violation can be helping to design a way around a compliance regime when otherwise it would need to be followed. So something for you to think about is, hey, we know this happens all the time. People do decide late in the game they want to put their, they get great advice from a CPA, says you'd better own this property in an LLC, not individually, and it comes in late. And there are definitely ways to think about doing that in a better manner, but if the entire reason is to avoid reporting, that's going to potentially create some issues for you down the road as you think about it.
Right.
Another question that we got in here, a lot of questions about, about the kind of, what about the lenders, and that, how do you know they have an AML requirement? The short form I will tell you is that under a number of other FinCEN rules that have been in place since 2013, every mortgage banker or broker licensed mortgage originator in the country has to have an AML program. And so therefore, it's really about, how do you know that somebody is a licensed mortgage company? And that's where the NMLS number comes into play. But you still do have to ask those questions and understanding it, especially with mortgage brokers today where, they might be brokering for a wholesale lender, but also for a hard money lender. You might want to be asking more thought-provoking questions in those scenarios. Let's do another question here. What about a scenario where you're not handling the closing, your customer, it's an all-cash deal, they just ask you to prepare a deed? Is that one where I'm going to have to be a reporting person here?
You're in the cascade.
You're in the cascade. Now, if there is a settlement agent that's ahead of you, then the settlement agent has the first responsibility.
That's right.
But what's not clear is, do you have to verify with that settlement agent that they are in fact doing the reporting? That's an FAQ. We need to put that one together, Steve.
It's certainly a good FAQ, but as Tom says, you're in the cascade. And so the question is just, is somebody else higher up? And if not, you're still going to be in there.
Yeah.
Here's a question maybe for Tom. In the scenario you talked about a customer who didn't want to provide the information, why did you just choose not to close the transaction instead of threatening to file a suspicious activity report?
That's a good question, and quite frankly, didn't have to cross that bridge. As I said, it was, with the rapport that we had with the client, we were able to talk turkey and tell them what the reality of what was imposed upon us, and then by extension, and they were willing to comply after we explained it, and so the transaction proceeded. And so, quite frankly, I haven't thought about that situation since we haven't encountered it before.
Great. So I know we're hitting the top of our hour. I've got two more quick questions I think we could hit before we go. One is, what if it's just what if the property is already owned by the LLC and it's just transferring the ownership interest in the LLC? Is that reportable?
I'm sorry, the property is already owned by the LLC?
Yes. Say you've got a nice big, beach condo and it's already owned by an LLC, and, new buyer wants to come in and they just are buying out the shares of the LLC or the membership interest in the LLC.
Ah,
So rather
I
than,
think,
so
what
you're
do you
saying
think,
rather
Tom?
than a deed transaction, you're talking
Yeah.
about
ownership transfers.
ownership.
Well, I think, well, it's a good question. FinCEN would say you have to report it and report the new beneficial owners of the LLC.
Yep.
That's what FinCEN would say, probably.
The short answer is the way this rule works is it is determined, the key transact is a transfer evidenced by a deed. So in that instance, right, just selling off the LLC membership's interests are not going to be evidenced by a deed, right? However, there is also, as Melissa said, this Corporate Transparency Act, whether it is going to still be in existence in a year, looming out there, and that would change a different, that would add a different level of reporting obligation beyond this rule to think about. The last question, and we'll get you out on this one, what if the buyer LLC is a builder, developer who's buying a lot what if it's a builder who's buying the lot and they're, intending to, build the house to then sell it? What is that, how does that factor into the thought process here?
I think it's covered. The builder intends to build a house on it. Even if they're doing it for profit and they're going to sell it after the house is complete, I think that's covered.
Right, it's covered. The basic rule of thumb is to think of it, it's covered unless somehow that builder qualifies for one of the exemptions to not be an an entity that's not covered by this rule. That, for a publicly traded builder, that's going to be a different story. If it's,
Correct.
you got high builder, I build 2 houses a year in the community, that's going to be a different one. I'm going to guess that you're not publicly traded on the New York Stock Exchange or any form of SEC registered debt collection. So ways to think about this, that just because it is a transaction that otherwise looks like it qualifies, there are still these exemptions that could come into play that could alter your reporting obligation, which is why our estimate number of 495,000 for 2023 is our high-end estimate, because we can't factor in those exemptions yet. But as you start to go back and look at your own book of business from the last year and try to do the analysis like Tom mentioned that his firm did, you'll start to get a better sense of what that real number looks like, especially as you start to understand, your clients, whether or not you do a lot of foreclosure work for banks, and therefore, that's going to factor in one way versus, you do a lot of stuff for high net worth individuals who buy stuff with trusts and things like that. I want to thank both Melissa and Tom for sharing their knowledge here again today. It was great. And again, for those of you that did join us at ALTA 1 in Orlando this year, you missed an even more robust version of this discussion. So I encourage you to keep the lookout for more of these conversations, because we've got great experts like Melissa and Tom that are going to continue to provide you with insight both here on this rule, but also how as we get closer to complying for December 1. Thank you all for joining us today. I'm going to turn it over to Jeremy to end today's webinar.
Well, I think you wrapped us up, Steve. I don't need to add any more superfluous words. But thank you for the overview and impact on operations. Obviously, this will be a continued education effort throughout 2025. Pay attention to ALTA's publications throughout the year. Our team, Melissa, Tom, will continue to develop education to help you on this journey. As a reminder, if you missed parts of today's webinar, I think others in your office would benefit from listening. A recording of the presentation will be available on ALTA's website at alta.org/webinars. And you'll also get an email tomorrow with a link to the recording and a link to download a copy of the presentation. That brings us to the conclusion of today's presentation. Take care, everyone.